Okay, I think we can get started.
Perfect. I was just about to ask, are we good to go?
We are good to go. Thank you everyone for joining us. It looks like we have about 36 folks joining us right now. We are going to record this session because we're going to offer it back out to all of the registrants and also to the York County Coalition on Homelessness mailing list for all the line staff that might not be able to all sit in on the same phone call or the same Zoom at the same time, but you'll still be able to see that information. So we'll make this available to you probably for 30 days. That's typically what we will do to allow staff to have time to review it. So with that, I am going to turn it over to Elena Herbst and Mark Unger, both from Tenfold.
Good evening or afternoon, everybody. Sorry. I'm really excited for y'all to be here. Looks like Jeremy's popping on as well. So I just first wanted to start with who we are. Tenfold's still fairly new to the York community, so it's kind of important to know why we're in the community. We are a Fair Housing Initiatives Program, also known as a FIP. What that means is that we get funding to provide education in both Lancaster, York, and this slide has not been updated, but now Adams as well, to landlords, property managers, tenants, municipal officers, lending institutes, pretty much anybody you can think of. When it comes to fair housing rights and landlord tenant rights. We do this not only through like one-on-one consultation, we operate a fair housing line, but we also have written resources. So some of you may have seen or heard of our landlord tenant guide before. We also can assist in informal housing resolutions when there are issues between a landlord and a tenant. And in just general, we provide technical assistance when people want to file a fair housing complaint. So all of that being said, if you've got clients who could utilize these services, good thing to know why we're here and what our purpose is. So a lot of today is going to be focused on fair housing trainers. It is a training specifically designed for providers. I think I can see the chat, but if you have questions, feel free to put them in the chat. And then we'll kind of try to get to things at the end there. But we're going to start here off with some fair housing basics. So this is just some kind of general context to how fair housing came to be. It starts with the Civil Rights Act of 1866, all the way back there. But it was officially deemed the Fair Housing Act in 1968 under the Civil Rights Act. And this gave you protections in the sale, rental, leasing or financing of a dwelling on the basis of race, color, sex, national origin, and religion, meaning that any decision made in allowing you to buy a property, rent a property, finance for a property, negotiate terms, things like that, all of those things could not be dependent on your race, color, sex, national origin, and religion. In 1988, the Fair Housing Amendments Act was amended to cover disability and familial status. A lot of people ask what familial status means. The thing to bear in mind there is just the presence of children or the attempt to secure children's custody or the presence of somebody who is pregnant within the household. So a landlord can't say, I'm not going to rent because you have children. The most recent update to the Fair Housing Act would actually be in February of 2021 when HUD released the Warden memo. This extended the definition of sex to include sexual orientation and gender identity. So this is all what we've just gone over here. This is all federal level, very high level. And then the state has their own regulation. The Pennsylvania Human Relations Act covers a lot of the same categories, but it does call out more specifically different groupings. So you've got your standard color, race, religion is covered. Pennsylvania Human Relations Act adds creed, age, ancestry, and the use or handling of a trainer or trained animal. But they all have all the same sex, ancestry, disability, all of that is still covered at the federal. And then if it weren't enough, we've also got the city level, which is super exciting that we actually have something in York, because not every local city does have something, but we do have the York City Human Relations Act. It adds the addition from the federal government of specifically calling out gender identity and sexual orientation. Like I said, we also do services in Lancaster, so I did include that in case any providers also had clients in the Lancaster area. They specifically call out gender identity as well. And then they also have possession of a GED as a protected class. And then I just kind of have this note down here that just because gender identity and sexual orientation are specifically called out at the city levels doesn't mean you're not protected if you're using the category of sex, because again, that protection that was edited in 2021 does expand the definition of sex at the federal level to include sexual orientation and gender identity. All right. So there are some exemptions that you should be aware of when you're thinking about fair housing, because people think, oh, well, I live in this house, so it must apply to me. The one scenario that I get a lot of questions about is like people living with family members. It's not listed on this list because it's not an official exemption. But if you're living with family, there are some weird regulations around that. And if you have that scenario specifically, feel free to reach out to us. But these are the 4 exemptions that are specifically called out. So housing for people of older persons, they are not, their policies and procedures demonstrate an intent to provide housing for persons of the age of 55 or over. So any scenario in which they are saying no children, no individuals who are currently pregnant, things like that, the housing is designed in a way that is for those who are 55 and up. So they are not discriminating in that scenario. The next exemption, known as the Ms. Murphy exemption. In this scenario, the owner of the property also lives in the property. So maybe you've got like a unit upstairs and a unit downstairs. The downstairs is occupied by the owner of the building and they rent the unit above them. They would be exempt from fair housing. At the federal level, it's no more than 4 units. At the PA human relation level, it's 2 units. So it would be the 2-unit scenario that I suggested or gave an example of at the state level. Next exemption is very similar to the Ms. Murphy exemption, just simply known as the single family housing exemption. This is if an owner does not own or have interest in owning more than 3 single family homes. They're a very small scenario there. They're only renting like 1 or 2 units. They would be exempt. The last exemption is religious organizations. They can show a preference for members of their religion as long as they're not operating for profit and the religion itself is not limiting based on race, color, or gender. The other thing to bear in mind about this one is if they're using a property management company to outsource any of their property management needs, they would also not be exempt, but that would be another scenario. So when we talk about fair housing, people ask, like, what does that implication actually look like? So when you make a filing, there are 2 different types of disparate actions that can come against somebody. So disparate treatment, this would be something that somebody directly did to another individual. So landlord A is saying to tenant A, like, I will not rent this unit to you because of XYZ. And that XYZ reason is because of a protected class. That is direct contact, direct words to an individual person. Disparate impact, on the other hand, is essentially affecting a collective group of individuals. So a policy that I have in place, I'm not saying specifically that I'm not renting to individuals of a certain race, but it does have a disparate impact and specifically impacts that race more than others. So the 2 examples we have here for treatment is someone specifically saying, I cannot rent the apartment to you because you have small children and I'm concerned about them falling off the balcony. That is a statement from one person to another that would fall under treatment. Disparate impact would be an advertisement that says 4-bedroom home available for a God-fearing family. This advertisement would have a negative impact on those who are non-Christian. So it would impact the Christian or non-Christian group. All right, so here are some of the terms to kind of understand what discrimination looks like. They are broad reaching terms, but we're going to get into some more specific examples in the next slide here. So just anything that's misrepresentation of a rental sale or negotiation. So saying one thing and then on the phone and then meeting somebody in person and saying another. Steering or segregating. So this might look like a provider saying, well, all of my families live on the first floor of the buildings. That would be making all families live on the first floor, segregating them to that level. Differing terms or conditions, like requiring somebody of one race to have a security deposit higher than somebody of another race for very similar units. Otherwise, just attempting to make housing unavailable. This can look like manipulation of wait lists, which is the next example. This can look like having an advertisement out and then seeing somebody who comes up to look at the unit and like pulling the advertisement, things along those lines. The last example we have here is strict occupancy limits. And I won't get into this one too much because Mark's actually going to go over this a little bit later in the presentation. But just enforcing limits that could arguably not need to be enforced. So let's look at some examples of what it actually might sound like. So we already gave the example of that 4-bedroom house available for a God-fearing family. The balcony example, charging people from another country a double security deposit because they don't have financial standing in the United States, even though they have income qualification. This would be an example of discrimination based on national origin. And then we called out this one specifically because disability is one of the highest filing rates of any of the protected classes. So we do kind of cover disability specifically for you guys here. So these might be examples of discrimination based on disability. I think you'd be better off in a unit closer to the facility since you need a cane to move around. That is not the decision of the provider, that is the decision of the client. Charging a person with a wheelchair a higher security deposit in case they scuff the walls or floors. So that's an undue burden to that potential tenant just because of their disability. Refusing to take a landlord reference from a group home or institution setting during the application process. If they had good standing in that previous housing, there's no reason that the disability orientation of that housing should prevent a reference from being accepted. Not accepting reasonable accommodation and modification requests for a disability that develops mid-tenancy. So like somebody's living in a unit, they become disabled, they put in a request for an accommodation or modification, which we will go over what those are, and saying, well, you didn't have this disability at the beginning, why do you need it now? We have a whole section on disability for you guys. So let's first start about what is considered a disability under the Fair Housing Act and what is not. It can be a physical or mental impairment that substantially limits or one or more of a person's major life activities. So when you think major life activities, you're thinking the ability to feed yourself, the ability to put on shoes, things like that. That also includes like mental health things. So when like you've had individuals who eat less due to a mental disability, things like that. The definition of disability under the Fair Housing Act also includes people with a history or perception of a disability. So a lot of people say this perception idea and they're like, I don't understand what that means. Well, the COVID-19 gave us a perfect example to give you guys. During the pandemic, anybody who was perceived to have had COVID-19 but had not been tested would be protected under the Fair Housing Act if they had been denied a unit because of having COVID, things like that. So that perception that there's a disability in play here. So that's a lot about what disability is, but what is it not? So it's not anybody who is currently using or abusing illegal substances. It's not a person who poses a direct threat, and you'll notice direct threat is put in quotes there because direct threat is one of those things you need to be able to see it happening now right in front of you, not a perceived threat that you think would happen. And then any individual whose tenancy would result in substantial physical damage to the property of others. And note that it does say others, not the unit, their unit, other people's property. So. And then, like I said a little bit earlier, which I think is the next slide, we'll see. Anybody who has a disability under the Fair Housing Act is eligible to put in a reasonable modification or accommodation request. Yep, perfect. Knew it was the next slide. All right. So very similar to treatment and impact when we're talking about the impacts of fair housing, reasonable modifications and accommodations are slightly different from each other. So a modification request would be an altercation to the actual property so that somebody can fully enjoy their unit. So allowing a tenant to put in handrails, grab bars, lowering the counters if they're in a wheelchair, things like that. A reasonable accommodation, on the other hand, is an adoption of the policies, procedures, or rules in order to ensure they have full equal access to the premise. So what this might look like is allowing assistance animals, allowing for parking spaces closer to the tenant's unit, additional keys if they have an aid, things along those lines. So it's an adaptation to the policies. All right, so we're going to specifically talk about assistance animals because it's a big question we get asked a lot. I'm just kind of do a real quick check on the chat, mostly just people looking like they're just checking in. Okay. All right, so assistance animals. A lot of people are not completely sure what they are, but we're going to go over them for you here. They do split into two different categories known as service animals or emotional support animals, but the biggest thing is they are not pets. They cannot be monitored the same way pets are in a housing scenario. Anything like deposits that would apply to a pet don't apply to a assistance animal. They're an animal that works or aids and performs some sort of task for the benefit of the person with a disability. The big thing to bear in mind when it comes to fair housing and just housing law in general is they're not actually required to be trained or certified. There are no restrictions on breed or size of an animal that's used, and housing providers could possibly deny the use of an animal based on the specific behavior of that animal, but not just because it is an assistance animal. So bearing that in mind. All right, and I actually have a lovely little chart for you guys, if I can get it to come up. Here we go. This is how you would break down animals when it comes to household animals. So you've got your pets. The other category would be therapy animals. These are temporary animals that come into the house for a therapy session, and then assistance animals. Then that assistance animals breaks in between service animals and emotional support animals. So let's go over service animals first. These are animals that perform a specific disability related function. An example might be guiding somebody who is low vision, alerting somebody who's deaf or hard of hearing of certain sounds, things like that. Under the Fair Housing Act, dogs are the only species of animal considered a service animal. However, if there's reason for there to be an exemption, and it's reasonable, exemptions can be made. So the example we have here is a monkey who's been trained to retrieve a water bottle from a fridge, unscrew the cap, insert a straw, and give the person their water bottle. Dog couldn't do that. So that would be why that exemption would be made. Another question we get asked a lot about is, are there breed restrictions on the dog? No, there are not. If you have a scenario where a landlord is kind of saying, well, my insurance says I can only have XYZ breeds in the house in order to maintain my insurance. Insurers are looked at as a housing provider under the Fair Housing Act. So they would be the one that would need to make the exemption to their rule to allow the animal. Emotional support animals. These alleviate one or more identified effects of a person's disability. They don't serve a specific task. They're there for alleviation. They can be any common household animal. So these are just some examples we have. And again, same scenario applies here. There are no breed restrictions. And if you run into that, the insurer is the one who needs to make the exemption. So say you get one of these requests. How are you going to process this? How do you look at this? What are your next steps? So first things first is you need to make sure who's requesting it is appropriate to request it. It either needs to come from the tenant or a legally designated representative of the tenant. So like in a scenario of a child with a disability, the parent is their legal guardian. There may be scenarios where older adults may have a legal representation that person could also make the request. According to the law, it either has to be verbal or written, but we always suggest written. This way you can kind of just like keep track of it, make sure where it's at in the process. It is always suggested that a request be made prior to acquiring the animal, although it can be made at any point. So if it's mid-tenancy, originally was a pet, they've developed a disability, that pet is transformed into an emotional support animal because they're alleviating the effects of that disability, they can ask for it to be considered an emotional support animal. The biggest thing is whatever you ask of the tenant, they cannot or should not share their medical history. You can ask for information about the animal specifically. So if you wanted the last known vaccination on the animal, what size it is, what color it is, like identifiable things about the animal, if they've had any history of violence, things like that, that would all be okay, as long as you're not asking questions about the tenant specifically and their disability. Where are we at here? Sorry, I kind of got off on a tangent. The animal should be necessary for the tenant to fully use the dwelling. So there needs to be a nexus between the disability and the need for the animal. That should typically be explained in a need letter from a healthcare provider. So they can get a letter from their care provider, whether it be mental health, primary care, whatever, saying that there is a need for the animal due to their disability. So that would be that nexus that I was talking about. And any sort of reasonable accommodation or modification request aside from animals should be reasonable. And what does that mean? It cannot cause an undue administrative burden. So that would be that classification. Refusal to allow tenants to even make a reasonable modification or accommodation request could be grounds for a complaint based on disability. So just always bearing that in mind if you, as either a provider of housing or a case manager, don't have a process yet for that, you can always reach out to Tenfold. We can kind of guide you on some tips, tricks on what's the best way to have tenants make those requests, keep your documents and records straight, that sort of thing. Oh, let me go back. Sorry, there we go. This is just a little bit more information. Like I said, a licensed healthcare professional would be the one that would provide the individual a letter of need. Online certificates do not count. However, and I'm making this really big, however, there has been an increase in online certifications, additionally doing a healthcare evaluation of people who make requests into them. That would be valid. The biggest thing to bear in mind when it comes to online certifications is that the fair housing law requires that the letter come from a healthcare professional who has seen the client. If an online certification center is doing an evaluation of the client and doing an evaluation of their disability, then in that scenario, yes, it would count. If it's just an online certification where people are paying for it and it's just plug and chug and developing a certification, that does not count. So that's the separation there. Like I said before, it should not have any information about the individual's medical history. It should specify that there's a disability-related need, and the healthcare professional's contact information should be on the letter. That's a good way to determine if it's legitimate or not, because if the contact information is on there, it's on there for the housing provider to actually reach out and ask questions and verify that they did actually provide the letter. Another big question we get asked when it comes to assistance animal is, what if there's issues with the animal? What if they misbehave? What's the next step after that? The biggest thing to bear in mind is under the Federal Fair Housing Act, assistance animals are seen as an extension of the individual. So any misconduct would essentially be like the tenant doing that misconduct. The tenant is responsible for ensuring that it does not create an undue disturbance for neighbors, staff, things like that. They're responsible for making sure there's no damages beyond normal wear and tear and things like that. I'm not sure where we're at. If there's a lease violation that was caused by the animal, it's as if the tenant did that lease violation. So they can be evicted if it gets to that point. Again, if the animal is aggressive, the landlord may request that animal be restrained while staff are in the unit to make repairs or do inspections. If it's excessive, again, it is as if the tenant is the one doing that behavior. So just bearing that in mind. And I will stop talking now. So Mark can talk to you guys a little bit about just some other considerations when it comes to fair housing. These may not be categories you've thought about before, but it's questions we get asked, so we wanted to include it for you.
Thank you, Elena. Hi, everyone. I'm Mark Unger. I'm the mediation and intake specialist here at Tenfold, and I'll be talking to you about a few other considerations. So let's start with fair housing and criminal records. This comes up a lot. It may seem like a niche category, but it is something we get asked about a lot. So the first thing we want to mention is that landlords are required, or not required, are allowed to require a background check. The caveat to this is that they cannot make the final decision solely based on that background check. Recent federal guidance ensures that they take into consideration the nature and severity of the crime. Whether it was parking tickets or something more severe. How old this record may be. So if this happened more than 10 years ago, they need to take that into consideration. What sort of rehabilitative efforts have been taken place since then? Have they been working with agencies? All of these need to be taken into consideration before denying someone flat out on a criminal record. Just one moment, please.
Looks like we have a visitor, so I'll take over from Mark here for a second. Like he was saying, any sort of blanket ban on an individual with a criminal record can have a disparate impact on people from protected classes. What that really means is it has been shown based on statistics that those of certain races or ethnicities are more likely to have a criminal record because of the unjust and unfair filing of criminal records against those of certain races or ethnicities. Same thing with those with a disability. They have a higher rate of having been in the criminal justice system. So having a blanket ban on criminal records altogether could be specifically impacting those of a certain race, ethnicity, or those with a disability. So that is why that is determined to be unjust there. There we go. Good to go, Mark?
Okay. Sorry about that. We're a small office of 3, so sometimes duty calls. So next we'll talk about source of income. This is considered a protected class in certain areas of the country and also certain parts of Pennsylvania. Right now in state law, the city of Philadelphia and the city of State College in Center County have codified ordinances having source of income as a protected class. So different sources of income that could be considered for discrimination if an application is denied because of it, if someone goes on these and they're up for eviction, that sort of thing, would be any sort of wages, SSI, Social Security, disability, child support, alimony, welfare assistance, veterans benefits, survivors benefits, and vouchers. So those are the listed wages in law right now. It's not a protected class here in York City or statewide or federally for that matter. But there are municipalities like the ones I mentioned that have that as a protected class. Let's see. Yeah, there are other considerations to take into effect when it comes to source of income. Depending on what that income is, it can be tied to other protected classes. If an application is being denied because child support is is part of that income. It can be based on familial status. Denying someone based on Social Security, disability, or general Social Security insurance can look to state level discrimination on age or disability for all levels. Next slide. So another area of fair housing we want to look at is occupancy limits. Like we mentioned before, it's, excuse me, the protected class that occupancy limits and discrimination would fall under is familial status, primarily with looking at what a landlord decides is optimal for certain families. Let's say the landlord wants to separate the boys and the girls of someone's children. That is not for them to decide. That is up to the parent. The one exception for occupancy limits is that there is certain, like the name implies, there are certain limits to how many individuals can reside in a home, but certain exceptions to that. Does the unit have larger rooms within it that could be considered a bedroom, like a larger living room or a den that might not be used? Yeah, and kind of looking at local ordinances on those occupancy limits as well for those that did not accept the International Construction Code ordinances. Next slide. Okay, so another concern we want to talk about in fair housing is domestic violence, because this is a very sensitive issue and it does come up every so often in fair housing discussion. So we do have a case study here. There is a case known as Ashley Butler and the Fair Housing Partnership of Greater Pittsburgh versus Sundo Capital, Michael Sundo, and Sladdak Holdings. The reason that we are able to provide this is that it has actually gone to a court hearing, so it is on public record now. Typically in the fair housing process, most of that information is kept confidential for the benefit of the complainant as they are investigating. But once it reaches a court, then it becomes public record. So the plaintiff was not allowed to end her lease early without penalty, even though she was being stalked by her abusive ex-husband. But prior to this case, domestic violence situations were typically not being considered in fair housing discrimination cases. The defendant said that the domestic violence survivor was not a protected class, that she could not file under fair housing law. The court found that neutral policy of defendant caused a disparate impact on the basis of sex, due to the fact that the majority of domestic violence survivors are female, as that would be covered under disparate impact on the basis of sex. The plaintiff did win in that case. The property manager was asked to add a clause to the lease for domestic violence issues, have a fair housing training, and pay damages as well. So that is something to keep in mind as you're looking at cases with domestic violence involved. Okay, so I did talk a little bit about the complaint process, but now we are going to go into more detail on this process. So I think Elena has a video ready to go.
I might have to unshare and reshare to get the audio correct. So give me 1 second here. Bear with me.
Let me just give her a second.
I think that worked. So let's see. Can you guys hear that?
I think you have to stop sharing and share the video itself.
Yep, that's with screens.
Okay, gotcha. I was
Mark,
why is
do it.
okay. Thank you for your patience, everybody.
Okay, Zoom is handy until it's not handy anymore.
I know. Share sound. Okay. Let's try that again.
We all deserve to be treated fairly when looking for a place to live. However, people are discriminated against in housing-related transactions all across the country. This is the story of one family's fight against housing discrimination.
Hello,
Hi, how can I help you?
I am here to ask about this apartment.
And when are you looking to move?
The 1st of next month.
Who's going to be living with you?
It will be me, my husband, and I have a son and a daughter.
You know, I'm sorry. We don't have any apartments available right now.
Well, thank you.
The Federal Fair Housing Act prohibits housing-related discrimination based on your race, color, religion, national origin, sex, disability, or familial status. If you believe you have experienced housing discrimination, you can do something about it. To get help with filing a complaint, you may contact a local fair housing organization or state or local civil rights agency. You may also file a complaint with the U.S. Department of Housing and Urban Development, known as HUD.
Hi. So, how's it going?
I'm on the HUD website, filling out the housing discrimination complaint form.
If HUD determines that your complaint is covered by the Fair Housing Act, it will send a notification letter to you and to all the parties who discriminated against you, known as the respondents.
Hi.
Hey, how are you?
We got a copy of our complaint from HUD today.
Kids, why don't you go watch some TV, huh?
Cool.
Your complaint is then assigned to an investigator, either at HUD or at a state or city agency with a law similar to the Fair Housing Act.
It'll be just a minute.
Thank you.
Hi, my name's Lisa. Come on back, let's talk. So why do you think that happened?
After I told her about my kids, she said that there wasn't anything available. But I think it might be because we're Latino, because I didn't see any Latinos in that complex or in that neighborhood.
Okay, let me look into this.
The investigator interviews all the parties and any witnesses and reviews documents and other information.
Hi, I'm an investigator with HUD's Office of Fair Housing and Equal Opportunity, and I've been assigned to investigate a housing discrimination complaint that was filed against your company. May I speak with a manager? Do you recall complainant visiting the leasing office that day?
Yes, I do.
And were there any others working in the office with you?
No, I was the only one working that day.
You described several unit styles at the complex. Now, how many of those have 3 bedrooms?
I'd have to check.
Sure, please.
Okay. I want to say it's around 40, 43, probably something like that.
40 to 43. And of those, how many have children living in them?
Again, it would take me a bit of time to go through my files to figure that out. I'm not quite sure.
Okay, and you are the leasing manager.
Yes?
So you're not sure as to the exact number, but I'll go ahead and note that for now.
Throughout the investigative process, which may take several months, HUD will also try to negotiate a resolution between you and the respondents.
Well, thank you all for being here today.
As I discussed with each of you, as part of HUD's process, we're required to offer the parties an opportunity to conciliate and basically settle their complaint. Would you like to explain why you filed your complaint?
We were looking for an apartment. We saw your listing, and I came to your agency to inquire on the apartment. When you heard that I had 2 children, you told me that it was not available.
I think it would be helpful if you explain how that made you feel.
It was embarrassing. To be honest, it was humiliating. Just to be flat out denied like that, you know, I felt...
In many cases, the parties do reach a compromise. However, if they are unable to do so, HUD will continue the investigation. Once the investigation is completed, HUD will notify you of its final determination.
Hi. Hi. Hey, got a letter from HUD today.
Let's see what it says.
If there is reasonable cause to believe that discrimination has occurred, HUD will initiate a lawsuit against the respondents. Either party may choose to have the case heard in federal court. If no one chooses federal court, the case will be heard by an administrative law judge at no cost to you.
Faisal.
Hey, how are you?
A government attorney will prosecute the case, and you may also hire your own lawyer.
Today you'll get to tell your story. Just relax, just be truthful. I'll guide you through with questions.
Okay.
All right.
If a case is decided in your favor, various things may happen. You may be able to lease the apartment you wanted. You may receive payment for out-of-pocket expenses and for pain and suffering, or receive the reasonable accommodation you requested because you have a disability. The housing provider will also be required to implement policies to ensure that others do not experience discrimination.
And here are the keys to your new apartment.
Thank you. We're close.
Getting closer.
Almost there.
Getting closer.
Hi, this is it.
This is it.
Our new home.
If you believe you have experienced housing discrimination, you can do something about it. For more information about filing a complaint of housing discrimination, please visit hud.gov/fairhousing or call 1-800-669-9777. To find a local fair housing organization, please visit nationalfairhousing.org. Fair housing is your right. Use it.
Let me stop sharing. I'm going to share here. Give me a second. Back at it. All right. So that was just kind of a video introduction of what the process looks like. There's this lovely little chart. We don't typically go over this in the trainings, but if you ever do want like a more detailed evaluation of what this process is, we do something called fair housing consultations. You can give us a call and we can kind of walk you through what the fair housing process looks like. But I'm going to pass it back to Mark here, talk about some other considerations so that I can get this to work. There we go.
Okay, so something else to keep in mind here when you're looking to file a fair housing complaint, or if you have a client that's looking to file a fair housing complaint, depending on the venue that you're filing to, whether that's federal, state, or a local agency, there's going to be different timelines that you have in order to file that complaint. So for the federal, at the federal level with HUD, you have 365 days from the act of harm or the date of discrimination to file that complaint. Both at the state agency, which is the Pennsylvania Human Relations Commission, we can put the link to that in the chat. And also for those in the city of York, it's the City of York Human Relations Commission. I can also put the URL in there. You have 180 days. That distinction at the state and local level, all forms of discrimination, housing, employment, public accommodation, education, all have 180 days. There can be exceptions made in certain extraneous circumstances. Excuse me. But for the most part, it is 180 days. So when you're looking at filing a fair housing complaint for someone who is under eviction, we do want to mention that the filing of a complaint does not guarantee an interruption of that eviction. There are other options that you can take if someone is under that process, whether that's mediation with the landlord outside of the courtroom. If the tenant is a disabled individual, they would be able to write a letter of reasonable accommodation to extend their stay in order to have an easier housing search while they're still at that property. But filing a fair housing complaint, unfortunately, doesn't stop an eviction because they are separate jurisdictions. The magisterial district judge does not hear these. So, and also there's a shorter timeline for evictions, typically around 30 days if they have a notice to quit, and then about 20 to 27 days after that. The fair housing complaint process can take upwards of 4 to 6 months at filing. So, 1 to 2 years, depending on the severity of the situation and which agency you're filing with. Next slide. So, as a service provider, this could be helpful, for realtors, property management companies, nonprofits that govern affordable housing, and even as service providers with employees. You could be. Some of this could also be applicable for an employment discrimination complaint, but we'll focus on fair housing. So if it is filed against you, you could be responsible for certain damages, like actual damages, out-of-pocket costs, for move out and other items, compensatory damages. That's a fun one. Such as emotional distress or humiliation, punitive damages, which would be decided by the court. You could also be responsible for the victim's attorney's fees if they do win the case. And then if you do file at the federal level, there are fees that HUD or fines that HUD sends out to the offender. That would be just over $21,000 for the first violation, $54,000 for a second violation, and $108,000 for the third violation. So it's definitely something that landlords and property managers want to avoid by sticking to fair housing law. So. Okay, Lena, did you want to take this part?
Yeah, no problem. So these are just some common provider fair housing mistakes that we put together. Most of them are probably common sense, but we always just like to go over them. Things like keeping records, inconsistency in applications or terms and conditions, things like that. Retaliatory, I think I said that right. Retaliatory actions, refusing to do a repair for some odd reason, and then immediately after that, filing an eviction, things along those lines. All adult or adult complexes only, a violation of family status laws out of concern for safety. Again, like we said at the very beginning with the example of the balcony, a lot of that when it comes to fair housing, it is the discretion of the parents who are the legal guardians of the children to determine what is safe for them and what is not. Failure to reasonably accommodate anybody with a disability. And again, that would be like on the basis of reasonability. So that might be something that would need to be looked at. Big one, failure to train your staff. So at least we're all completing that now. Unreasonable occupancy standards. Mark talked a little bit about that, how that can protect familial status. And then just failure to communicate with tenants. So doing actions without communicating the reasonings behind them or the causes of them, things like that, could get interpreted as actions done based on somebody's protected class. Where did my mouse go? There it is. And then just some best practices we have for you guys. Know the law and stay up to date. The most recent change to the fair housing law happened in February of 2021. So while it doesn't happen every year, just keeping up to date and making sure that you know what's going on is always a good idea. Establishing non-discriminatory policies in your writing. So specifically calling out the decisions of this application will not be based on race, color, religion, gender, so on and so forth. Training all your staff frequently. So even though it's great that we're all here, I assume, and maybe in the future, not all of us will still be in the same positions. So having your staff trained regularly is always just a good idea. Make sure that anybody who missed the training last time gets it the next time. And again, just like keeping records, that's something we talked about in the beginning. When you don't keep records, you can't show that you didn't discriminate. And when in doubt, ask questions. Like I said at the beginning, we are a FIP, a Fair Housing Initiatives program, which means our funding is not just for tenants. It's for people involved in the housing arena, landlords, property managers, caseworkers, community members. I've had people call about their best friend's housing situation. Ask questions. And I will be the first one to say, if I don't know the answer, I will try to find it out for you. So even though this is a specifically fair housing oriented training, I did put this in here. And I just wanted to see where we were at with time before I continued with this one, because I still want to give you guys time to talk about, like, if you have questions or anything. But I did know that, like, when Kelly reached out, there might be some new caseworkers. So learning about the eviction process might be a smart idea. What are we thinking? It's
I think we have it booked until 4:30, as long as folks can hang tight. And if they can't, they can always go back and review the end of the recording. So I say go ahead and talk a little bit about eviction.
Okay, perfect. So a big question we get when people call in, they're like, oh my gosh, I received this notice. How much time do I have before I have to be out of my unit? Blah, blah, blah. So I put this section together, it just kind of goes over timelines so that when you do receive those clients who come in a panic, you can say, this is how much time we're actually looking at. Let's take a breath. But the big thing I want to go over here first before talking about timelines is the difference between an eviction and a non-renewal. So according to the Pennsylvania Landlord Tenant Act, there is something as known as a non-renewal. It happens at the end of a lease clause. So say you're on a year-long lease. At the end of that year-long lease, a landlord could give you something known as a non-renewal. This allows property managers or owners the ability to use the property differently. Maybe they don't want to be a landlord anymore. Maybe they want to sell it. Leave a contract with somebody who's just not been very compatible with them, things like that. This is not an eviction. That's the biggest thing to bear in mind. This does not go through courts. This is just a termination of the contract at the end of the term. Big thing to bear in mind here is for those who are on a month-to-month lease, this theoretically could happen at the end of any given month. Month-to-month leases start and end every month. And according to Pennsylvania law, they only need a 15-day notice. So say you're in the middle of the month, you're on a month-to-month lease, and you get a notice on the 15th of the month to be out by the end of the month, that is a non-renewal. The only scenario in which this isn't the truth is if your lease specifically calls out a differing timeline. So if your lease calls out that the landlord needs to give you a 30-day notice, that's what they need to stick to. If they need to give you a 60-day notice, that's what they need to stick to. But minimum Pennsylvania law says 15 days for a month to month. Now, what if we're on that year-long lease? What kind of notice is required then? That is a 30-day notice requirement. But again, if your lease says something different, the lease trumps that. So if the lease says 60 days, that's what the landlord has to give you. So what happens in a scenario where the landlord wants to terminate the lease contract before the lease term is up? This would be considered, there has to be a breach of the lease. So the tenant themselves had to have violated the lease in some way. They would then receive a notice to quit. The notice to quit outlines how the lease contract was breached, if it can be remedied, how it can be remedied. This is not a formal court document. This is a letter given to you by your landlord. There is no law that says it has to be typed, but we always tell landlords it's probably a better idea for something a little bit more formal than just a handwritten note. That doesn't hold up as well. The other thing to bear in mind is that a lot of modern leases actually waive your right as a tenant to receive that notice to quit. What does that mean? That means when you sign that lease, if there is a waiver to your notice to quit, you're saying, I don't need a notice to quit in order for you to start the eviction process. They don't have to give you that notice that you violated the lease in a certain way. They don't need to give you a way to remedy it. They can immediately go to filing with the courts. That filing is known as a landlord-tenant complaint. So this is a lovely little graphic I put together for everybody so they know timelines. So this is not accounting for the time of a notice to quit. A notice to quit is the 30-day notice. And if you're on a month-to-month, it can be 15, very similar to a non-renewal. So this timeline here is not accounting for that time to either remedy or leave the property. This is from the moment a landlord-tenant complaint has been filed with the courts. Once that has been filed, a court date has to be scheduled from 7 to 15 days out. So either a week out or 15 days out, somewhere in that timeline. Once a court hearing has been filed and the court hearing happens, a judgment has to be made between 0 to 3 days. So it could be made right there in that court setting. The judge may say, this is my judgment right there, but they have up till 3 days to make that judgment. Once that judgment has been put into place, there is a 10-day window that the landlord has to wait before they can make an order for possession. So that 10-day window is actually to allow you to make an appeal. I didn't put the timelines on like the appeal process because there's like some specifications if it like the eviction was for non-payment or a different type of breach of lease. And if you'd like information on the appeal process, you are more than welcome to reach out to us and we can kind of go over that with you. But in general, once that 10 days after the judgment has been put in, that's when a landlord can make an order for possession. So order for possession is the actual form that they fill out saying, I want to take possession of this property back now that I have won my court hearing. They don't have to make that order of possession, which is a little funky, but they have to at least wait 10 days before they can do it. Once that order of possession has been filed, it has to have another 10 days before they can actually have that lockout date. So if you're going with the minimum dates here or timelines here, from the moment landlord-tenant complaint is filed, you have about 27 days. If you're going to the maximum with the 15, the 3 days, the 10 and the 10, you're up to 38 days. So you've got a window between 27 to 38 days from the moment a landlord-tenant complaint is filed against you before you go to a lockout. So I know that's a lot of content. I broke down each of these steps in the next few slides here. So this is what the landlord-tenant complaint would look like. It's filed at the Magistrate's District Judge Office. Approximate filing cost is around $140, and the landlord would pay that upfront. Some leases have it in their lease terms that if eviction has to be filed against you, you agree to pay any of those filing fees. So just bear that in mind. If it's a scenario where somebody is getting filed against because they didn't pay rent, they may owe the rent and then filing fees. And then we already talked to say 7 to 10 days for the court to be scheduled. This is the actual form that would tell you when your court hearing is. It would have where you're to report, who is which honorable judge, all of that fun jazz. The biggest advice I can give to anybody facing eviction, go to the court hearing. Encourage your clients to go to the court hearing. Go to the court hearing, go to the court hearing, go to the court hearing. If you find yourself in a scenario or have a client in a scenario that they're about to go to a court hearing, they don't know what to expect, they don't know how to prep. One of the services we do offer is we can kind of sit down with them, look at the paperwork they've got, look at the reasoning for the eviction, kind of talk them through, okay, if it was you withheld rent because of a damage, make sure you have documentation of that damage. If you have an assistance animal that the landlord approved but is now saying is a pet, and that is a breach of the lease because there's a no pet policy, things like that. Make proof that you requested their assistance animal, all of that jazz. We can kind of walk them through that process. So when judgments are made, and this is typically on the basis of money judgment, but you'll see there's different types of judgments that come in. This is the judgment that you would get notice of. There's 4 different types. Possession granted if money judgment not satisfied. This is also known as a pay to stay judgment. If you pay the rental arrears, you can stay in the unit. Possession granted, meaning regardless of if there's monies due or not, the possession was granted to the landlord and a order of possession will be filed. Possession not granted. This is a scenario where honestly nothing next happens. Possession is not granted to the landlord and you don't owe them money. And then there's the just a money judgment, meaning you keep possession of the property, but you still have to pay them money. All right, so this next section kind of happens specifically when we're talking about pay to stay. Some of the information in this slide is not specific to pay to stay, but majority of it is. I just kind of wanted to give that preface. So if a landlord is paid in full, including judgment costs, any ancillary fees that you agreed to be paying according to the lease, whatever, within 10 days of the judgment, that means that no order of possession can be requested. So if they established you owe the landlord $2,000 and you got that judgment, you made that payment, no order of possession. If the landlord is not paid within those 10 days, or no appeal is made, because that's also the window that an appeal can be made, the landlord would then be able to make that order of possession. A forced eviction date will be scheduled 10 days after the order of possession is posted. So now we're looking 20 days out from that judgment. Let me move you guys so I can see my own handwriting here. Got to move the little camera where everybody's at. Okay. That order of possession date will be posted on the door by the constable. Up to and including that date, the tenant can pay the judgment in full to avoid the eviction altogether. And again, this is where I'm talking about that pay to stay judgment. If the tenant pays the before the eviction date, arrangements should be made with both the landlord and the constable, just so they know what's going on. Everybody knows what's going on. Constable doesn't show up because the landlord's claiming you still didn't pay when you definitely did, that sort of thing. Make sure you make those arrangements. If the tenant wants to pay on the day of the eviction, it has to be in cash. They do not accept checks, and that payment will be made directly to the constable. But in that scenario, the eviction will proceed as scheduled. It's just you're making the payment. So bear that in mind as well. And then this is a graphic. This is from our landlord tenant guide, which you are all more than welcome to get a copy of. They're on our website. I can also get you physical copies because we have some in here in the office in English and in Spanish. But these are just some sample clips from that guide. Kind of goes over timeline requirements. You'll see here where I was talking about expiration or general breach of a month-to-month lease, that 15-day notice requirement. But when you're expiration or general breach of a lease on a year lease or less, 15 days, longer than 1 year, 30 days, all of that sort of stuff. This goes down through that timeline that I was talking about where like how many days till the actual lockout can be calculated, 15, 3, 10, 10, all of that sort of stuff. I did want to talk about getting your belongings back, because that's a question I've been getting a little bit more frequently. If the tenant wishes to retrieve their belongings once they've been locked out of the unit, they need to let the landlord know within 10 days of the lockout. The landlord would then hold the belongings for at least 30 days if they've been notified. They can be moved. They aren't required to leave the items in the unit. And if they're required, like if the landlord puts them in a storage and incurs fees for storing the items, they can charge the tenant for those storage fees. And then the landlord and the tenant would arrange a time to get the belongings. Self-help evictions. I just want to go over this as well. This is essentially the practice of forcing a tenant to move out by either locking doors, turning off utilities, or finding another way to just make the unit uninhabitable. This is not permitted under Pennsylvania Landlord Tenant Act at all. And if a landlord attempts this, we always suggest seek legal service, but also if it's happening right now, call the police. And then this is just some of our contact information. Where are we at time-wise? Oh, I went through that a lot faster than I thought I could. Whew. I just wanted to open up for a Q&A and ask people if they had questions for us. I saw some of them were coming in and I just didn't get a chance to look at them yet.
I took care of those, Elena.
I was gonna say, I think the other Elena answered those. They still came up as Elena.
Any questions people have for us?
Oh, here we go. Here's one in the chat for you.
Okay. What if the patient was in the hospital during the 10 days? Is that what we're asking about?
I think so.
Okay. Gotcha. When you're trying to retrieve the belongings. Okay. So like I said, that 10 days after the lockout, that's when you have to ask for that. In that scenario, if you know you're in the hospital and you're like the person's unconscious or things like that, I would actually kind of make the recommendation to have a representative of the tenant make the request. But if you're beyond that at this point, it's a retroactive thing. I'd actually want to look into that for you if you don't mind, because I'm not sure what the answer is. But my guess would be something along the lines of like an MDJ filing to get your belongings back. That would be my guess. Again, I want to look into that for you if you don't mind. Are there any other questions here in the chat?
And I should say, if it's helpful, we can provide follow-up on the questions that needed a little more research so everyone can see them. But we can also, if anyone, if Tenfold needs to connect with any of you individually about your questions, I have contact info for you and I'll make sure they have it.
Yep, and I have listed everybody's contact here. So if you're real quick or like, maybe I have this question, but let me just jot down their email real quick. Feel free.
I just wanted to mention that a lot of the questions that I was answering involved reasonable accommodations. We do actually have templates for reasonable accommodation requests and modification requests. So if anyone has clients that are looking to do that, or if anyone's looking to do that personally, we can provide that for you.
Yeah, that is one thing that we get asked, that can provider ask a tenant to fill out a form about their emotional support animal request or just general accommodations request, and they can. That's fine. Again, the form should just not call out like, what is your disability? That's not okay. One of the questions was, will we provide the deck slide? Yes, that's easy.
There was a question early on. I saw Jeremy having some interaction, but I don't know if it got answered. I was going to scroll back up and see if I could find it.
Was it the one about providers refusing to write letters?
Yes.
Okay, so I've actually been doing some research on this because it was an issue that came up recently through somebody who reached out. I've actually even reached out to the Pennsylvania Human Relations Commission about this because I wasn't sure. And I can't remember what the exact complaint style they recommended because they still wanted to do more research when I asked them. They were like, give us some time, let us look into this. But their gut reaction was that you could file against the provider for refusing to give adequate care. But I forget what kind of complaint that's called. It's right there on the tip of my tongue.
It's a public accommodation
Thank
discrimination.
you. Thank you. Yes, that one.
Yeah.
So
you would actually file against the medical or mental health provider, not the
Mhm.
housing provider.
Yep. But yeah, like I said, I'm looking more into that. And I'm just kind of waiting to hear back from Pennsylvania Human Relations Commission because they're doing some more research for me on it. It's nice to have people in high places where you can say, hey, I don't know this. Can you? So
I saw some of your people in high places last week. Okay. Any other questions for those of you attending? If not, you can
guys
always
do think
answer
of-
later.
yeah, but I'll say if you think of something like later and you're like, oh, that would have been a great question, feel free to reach out.
Okay, perfect. We will get the recording and the slides out. Try to get that done before the end of the week, so you guys and you can share it with your other mates if they weren't able to join us. And thank you so much, Jeremy, Mark, and Elena, for helping us out today. We appreciate it.
Yeah, of course.
All right. Okay, take care, everyone.
Bye, guys.
Take care.